Hi everyone, my name is Zameer Nathani and today we'll be going to discuss about enforcing IPR beyond the boundaries. Uh, First, a small introduction from my side. I've done my law, I've done my LLM, including international laws, United Nations, WTO. I've done my PLD from Harvard Business School. I've done my executive MBA from Narsi Monji Institute of Management Studies. I've done my US IP laws from Stanford University. And I've done intellectual property rights certifications as well as ADR certifications in IP from World Intellectual Property Office of United Nations. I've done my private equity from London Business School and I've done M&A from Harvard Business School. I started as a law firm attorney and I worked for global corporates, including great names like Eureka Forbes, LG Electronics, Johnson and Johnson, and many countries across in US, UK, and Asia Pacific. I was also the associate vice president in Reliance Entertainment, which was at that time in 2006 into business of gaming, OTT, and e-commerce world, what we are talking about today. I was also head legal for Balaji Telefilms Ekta Kapoor, which is a well-known production house in terms of TV show. I was also head legal, director legal and general counsel for Raymond Limited, which is a very well-known textile and clothing company in India. It's a 90-plus-year-old company, having a presence across globe and also the IP registrations, etc. I'm presently Senior Vice President and General Counsel for UFO Movies, which is one of the pioneer and disruptor in the technology where physical reels of the movie were replaced by digital projectors in India and globally now. I am also the recipient of the Harvard Business School Alumni Challenge Award from Harvard Business School. I'm a recipient of the Alumni Achievement Award from Narsi Monji Institute of Management Studies. And in addition to the other renowned awards which I have received, I'm also the recipient of the General Counsel for the Year Award of 2019 from Indian National Bar Association at the gracious hands of Justice Sri Krishna, who's a mentor, who's the ex-judge of the Supreme Court of India, and also was the chairman of the Committee on Data Protection Laws. Coming down to the discussion we would have, number one, we are going to see some numbers and the general global scenario. Number two, we are going to see some case laws in India and also abroad. We are also going to see what are the issues which are coming up globally in terms of intellectual property rights, as well as India jurisdictions, what developments have happened. We are also going to speak about International IP Index, which is a report by US Chamber, where top 5 countries are rated, which is US, UK, France, Sweden, etc., where India also is now on 36th position. It has gone literally 8 spots up in terms of the intellectual property key strength areas. That's the flow of the presentation, where you will really see the depth of the content and what is happening in the intellectual property landscape. First, navigating the international patent landscape. According to the WIPO indicators of 2019, these are official reports which are collated and then published at a later stage. 3.3 million patent applications were filed in 2018. See the amount, the quantum involved towards patent registration. Number two, an estimate of 1.42 million patents were issued in 2018. Shares of rejected applications were highest in UK and US. US-based businesses file the most PCT applications, which is your patent common treaty applications of WIPO, United Nations, but are trailed closely by Chinese entity. All right. Asia received 65.1% of all applications which were filed worldwide in 2017. It was 49.7% in 2007. Now we have gone 65.51% in terms of the overall applications for intellectual property rights registration happening in Asia. Inventors filing patents abroad came from US, Japan, Germany, Republic of Korea, and China. Patent applications were most likely to be rejected in UK and US and accepted in Australia and Russia. So see, this is a jurisdiction disconnect we have got, where one country may reject your application and another country may say it's a valid patent and we accept that. There was increase in China litigation based on increasing enforcement. Ongoing trend for parties litigating in multiple jurisdictions at the same time was observed in case of China, Japan, Europe, and United States. India came out with a great bilateral arrangement with the government of Japan, where a patent prosecution highway program to expedite patent examination in India was also entered between Government of India and Government of Japan. This program is one of the great steps which have been taken by Government of India, because it has some good merits in that which will benefit not only the law, process, governance, but also our footing on the international standards in terms of IP-friendly jurisdiction. Government of India approved the proposal for bilateral patent prosecution highway program. It's a maiden initiative with Japanese Patent Office. It will run on a pilot basis for 3 years. This bilateral arrangement between the Patent Office aims to promote or to achieve and promote the work sharing mechanism between the India Office, Indian Intellectual Property Office, and Japan Intellectual Property Office. So work sharing would also mean that there would be sharing of productivity and efficiency between the two IP offices, which will benefit India. Number two is that to enable faster processing of patent applications. So these are two remarkable achievements which are focused on achieving in this bilateral arrangement. One is the work sharing environment, which may help both countries in the efficiency standard. And second is to enable faster processing of the patent application, which again benefits both the countries, which will then be looked upon as a friendly IP jurisdiction and a faster IP processing jurisdiction. After going through numbers and one of the remarkable bilateral agreements which India had with Japan, we now reflect on the cases which have come up, which are showing the indication in the IP world of what is happening on the enforceability side and what is good happening and what needs to be looked into it so that it can be futuristically interpreted on IP protection. One of the remarkable judgments we got from Delhi High Court was in the case of Make My Trip versus Make My Travel. This is a 2019 judgment by Delhi High Court, where Make My Trip had gone to Delhi High Court to say that Make My Travel is using Make My Travel words, which is very similar to Make My Trip. And there is a doubt or confusion which is created in the mind of public that this is a similar company. Now, under the Trademark Act, if you see it under the Trademark Act, it is written very clearly that if there is a usage of the mark for more than 5 years, you have acquiesced to use that mark. You have consented to use that mark. That interpretation of remaining silence has been dislodged by the Delhi High Court by saying that mere silence does not amount to consent or acquiesce, and Make My Travel cannot use that mark. The Delhi High Court in a recent matter has granted temporary ad injunction in favor of Make My Trip in a trademark infringement case. The court held that the word marks used by the defendant were identical and deceptively similar in nature, concept and idea, which are evident from use of the words in specific combination. This principle becomes important as it upholds the principles that mere silence or non-intervention does not amount to acquiesce or consent of using that particular mark. All right, acquiesce was one of the most critical areas to be addressed. Delhi High Court has now addressed it very prominently. The next case we have is Steer Engineering Private Limited versus GlaxoSmith line. Now, this case is also very important from the perspective of copyright. So we saw a trademark case of Make My Trip. We are now seeing a copyright case where the Karnataka High Court has gone into some detailing on what basis we can grant you copyright protection when you come to the court alleging that there is an infringement of copyright. Now, what happened in this case? Let's look at here. The Karnataka High Court stated that there was no infringement of copyright as the appellant had failed to produce the original work, which is the test results, and instead produced a redacted document, which means normally what happens when we go to the court, we say to the court that everything is very confidential, I can't disclose it. I have only disclosed the relevant portion, rest I have redacted or I have hidden or I have blackened it. Okay. Now, there is a balancing between the confidentiality and the copyright factor. The court said the appellant has failed to indicate confidential nature of such information at the time of transfer under the master service agreement. The case throws light on the laws relating to confidentiality and copyright of test results in India, which means when you don't say that this was of a very confidential nature, where you may have an agreement which says confidentiality clause, but then the court went into the detail and said that the appellant failed to indicate the confidential nature of such information at the time of transfer under the MSA. This case throws light on the laws relating to confidential information and copyright of test results in India. This decision may get digested somewhere or may become a subject of appeal, but it is balancing between what is confidential and what is copyright protection which can be granted, and that balance has to be reflected in all the future proceedings. The next case we have is for outside India. It's in the case of Helsin versus Teva Pharmaceutical USA. When an invention is sold privately and the purchaser is obligated to keep the invention secret, does this sale count as prior art that would prevent subsequent patenting of the invention? The court ruled that such private sale is indeed prior art that prevents later from patenting of the invention, which means that even if you privately sell a particular patent, that private sale amounts to a prior art, which means it was known to you that I am the owner of that particular patent, and which has been now sold to you in a private sale, and that would indeed amount to a prior art. And prior art means that the person who is buying it can't go to the patent office and say that this was a private sale, it was not in the public, not known to anybody, he has now sell it off to me, and therefore I am the inventor or I am the assignee and I have the right to register this patent in my name. The prior art establishes who was the inventor, who was the owner originally, and it has now only been sold, and therefore this prior art existence will always remain. The ruling avoids a major change in the patent system. Had the court ruled that private sales are not prior art, the decision might have encouraged pre-patent commercialization, which means if people would go and sell their patent saying that, it's in the process or it's not been patented, and those commercialization activities would take place, which would then further give rise to some dispute if that patent does not turn out to be a patent which has credibility to be granted patenting in future. All right. So the court said that even if there is a private sale or a public sale, prior art means that it was existing, it was made by somebody else, it was in the knowledge of the subsequent buyer that there is an invention which has been owned by somebody else, whether it's a private sale or a public sale, prior art will remain, and therefore the later can't go and register that as a patent. The next landmark case we have is about Goldman and Breadbit News, USA. Now, this judgment is very important because today when you go to Google and write any name, you see a photograph which also comes up in Google. If you write a name of ICICI Bank or if you write Microsoft, those names, logos, photographs of Bill Gates, etc. will be shown on the website. The only thing when you click on those photographs, Google has put a disclaimer saying this photograph is subject to copyright. Now, Google also goes on to argue that I am only showing those photographs which are available in public, which means today if I type the name of Bill Gates, it is actually showing a photograph which is already there in the public domain on some website or some news channel or Microsoft, and Google is only displaying that photograph from the public source. So Google virtually is saying that I am only showing something which is already available in public. Now, this co-interpretation of the case is one of the interpretation which says that there might be a case of infringement if it is shown without authorization. So this is a judgment which basically threatens the world of internet. A federal district court ruled that web pages can infringe simply by embedding a copyrighted image without authorization. This conflicts with the Ninth Circuit's interpretation of the Copyright Act. A defendant's web page is displaying an image only if a copy of the image is stored on the defendant's server. If the defendant's page merely links to the image itself doesn't appear on the page, so there is no infringement. The district court's ruling in this case threatens to undermine the internet as we know about it. The next judgment we have is Texas Advance versus Renesas America. Now, this judgment is very important from the perspective that whether a US court will have a jurisdiction for another country if the offer for sale was made in United States, but the actual sale has taken place outside the United States. All right. The alleged infringer sold the infringing product outside the United States, but the offer of sale was made in the US. The federal court ruled in this case that the infringement did not occur in the United States because the contemplated sale was outside the United States. Now, Texas Advance has now filed a review in the Supreme Court. The court has also has now asked the Justice Department to offer its opinion on the case, because this case would have a lot of impact, because if Supreme Court of United States decide that there is a jurisdiction available, that would be an issue of a sovereign country becoming amenable to the jurisdiction of United States based on the facts. If they are similar in these cases, then it can apply to all the future cases. Now, we have seen numbers, we have seen the bilateral treaty which was entered between Government of India and Government of Japan. We have just seen important cases in India and USA which would have impact on the IP regime, intellectual property world globally. Now we are going to analyze what were the key developments which have happened in the global IP market with focus on APAC, US and UK. According to the 2020 US Chamber International IP Index that maps the IP ecosystem of 53 global economies representing about 90% of the global GDP. IP remains at the crux of the China trade dispute. Recent free trade agreements have failed to strengthen the global IP standards. Developed and developing economies alike are undermining biopharmaceutical innovations. These are critical observations which are coming at a global level. Several emerging markets have made progress towards implementing a range of pro-IP measures in order to attract investment. So this is a good development which has been reported. Like, for example, we spoke about the Government of India and Government of Japan initiative. The moment you become IP-friendly jurisdiction, the moment you become good adjudication jurisdiction, you also attract investment in the country. Global issues which remained between US and UK were in respect of the patents and geographical indications. In 2019 November, Labour Party obtained confidential documents from trade negotiations between UK government and the US, which details the US position regarding intellectual property provisions. The US said that it had concerns about the European Union's approach of including list of geographical indication names to be protected in the trade agreements, which can have an impact or effect of preventing US producers from using the name of the European Union geographical indications on their products. All right. On the patenting side, the document showed that the UK and US had discussed lengthening patents for medicines, with US officials having pushed hard for longer patents for US drug companies. Now, when you talk about the geographical indications, it's about the cheese, it's about the Darjeeling tea when we say, so Darjeeling tea is a geographical indication for the tea which is grown in India, etc. So after the example of the geographical indications which I gave you for India to explain the context, the other global jurisdiction where intellectual property discussions have been on the forefront and the news is the United States and China trade negotiations, which dominated the international policy environment also. This culminated into the January 15, 2020 signing of phase 1 of the economic and trade agreement between United States and China that will strengthen the national intellectual property environment in China and better define and protect right holders' legal interest in some key areas. Together, the Chinese and American economies constitute close to about 40% of total global economic output and are the world's biggest trading partners. What is the trend which you see in India? India has a very positive trend which has been seen in terms of intellectual property rights, with the right holders being able to defend and enforce their copyright through injunctive relief. Access to websites offering pirated and infringing content have been disabled through court orders, including the notorious international sites like the Pirate Bay. In April 2019, the Delhi High Court issued a so-called dynamic injunction. Such an injunction addressed the issue of mirror sites by disabling infringing content, which reappears in the public domain by simply being moved to a different access point online. So this judgment basically means that if somebody copies ICICI website and puts a mirror website as a fraudulent website, and when you take an injunction against that website, he can't go back and open a new website and say that this order has still not been applicable and therefore this site will not be put down. The dynamic injunction says even if the guy goes on to make a new website or goes to a new server or does anything, it applies in all the cases. You don't have to come back to the court on case-to-case basis, which is a very positive and a great development which has happened in India. Exploring ways to register and protect IPRs in foreign countries, one of the checklists which you should always keep in mind. We discussed about the numbers, we saw about the Japan treaty between India and Japan. We saw some important cases and we saw the global disputes which have intellectual property implications. We are now exploring ways to register and protect intellectual properties in foreign countries. What is the checklist you should keep in mind? Number one, maintain secrecy, including through confidentiality agreement before filing the patent or design application. Number two, check the patent or design database for prior art and monitor your competitors' activities. Number three, check the registrability of your patent or design with a local IP agent or attorneys. Remember, we had a discussion in the past slides where US and UK jurisdiction will reject your application of patent or IP, where some jurisdiction would accept it. So it's better to have a cross-check done at a local level, at a local IP agent or attorney level also. Design strategies with a clear understanding on how far local laws can be interpreted and practically enforced, all right? When you're dealing, for example, for a gambling website or a IP which has a gambling component in that, and then you keep it for the Gulf jurisdiction where gambling, etc., may not be permitted within the Sharia Act or something. So understand the local laws, how it can be interpreted and practically enforced when you're also registering intellectual property rights in foreign jurisdictions. One of the best mechanisms we have got now is the Madrid system, which means you want to file trademark, you want to file any IP registrations, including patent under PCT. The Madrid system offers you the most simple and economical procedure. Why do we say economical procedure? Because if you go to individual countries to file intellectual property registrations and enforcement, it's a very expensive affair. The Madrid system gives you economics of trade, where every jurisdiction can be tick marked and there is a nominal fee attached to it, because Madrid is based on a treaty between the countries, and therefore this system has been offered globally. It allows companies and individuals to obtain and maintain protection for their mark in an ever-increasing number of countries by means of a simple and economic procedure. The most important thing one should always remember here is that when you go for Madrid Protocol, your first application in the parent country or the mother country is very important for registration, and you should have some visibility on whether this mother application will be accepted, because if it is rejected, it may have impact on the common application for multiple countries which you have filed using the Madrid system with the same description what you use for your mother country. And therefore, if there is a disbalance between the two, if your mother country rejects it, there is a probability of an objection in your common application also, which may fail in some countries or all the countries, but would certainly have an impact. All right. So keep that in mind. If your mother country is accepted your IP registration, then there are chances that when you go for multiple countries under Madrid registration, chances are that these countries will also accept those applications, considering that the mother country has evaluated the same and the trademark, copyright, or patent has been granted to you. For example, when you file in India, so India becomes my mother country. My first application and my business is existing there, and then I expand to other jurisdiction using Madrid system. The Madrid system is used by 1/3 of worldwide applicants seeking protection of their marks through the Madrid system. Of these, about 80% may be categorized as small and medium enterprises having a small portfolio of 1 or 2 marks. In terms of the India jurisdiction also, there has been a lot of progress on the enforcement side. We have seen the positive developments which have happened is the ongoing actions which have been undertaken by the recently from Maharashtra Cyber Digital Crime Unit, as well as the Telangana Intellectual Property Crime Unit and the Indian Domain Registry (NICSI) to suspend domains engaging in infringing activities. The website of the Cell for IPR Promotion and Management, established by the Ministry of Commerce and Industry, also provides the most recent statistics of patent, design, trademark, and copyright, as well as free of charge educational resources. So, India has been at the forefront of improving knowledge, governance, process, laws, and the courts have been also addressing intellectual property issues rightly. And this whole framework elevates the level of India jurisdiction as a IP, good governance, and IP friendly jurisdiction. There were some areas of concerns which came up, which has now been addressed by the government. There was some premature refusal of trademark applications which were happening without giving due consideration to all the relevant factors such as trans-border reputation, international use, acquired distinctiveness. There were restrictive patentability criteria combined with difficulties to enforce patent granted, absence of an effective system for protecting undisclosed tests and other data generated to obtain marketing approval for pharmaceutical and agrochemical products against unfair commercial use. These are all areas which are now being addressed by the India jurisdiction. It could also include broad criteria were applied for granting compulsory licenses or for revoking patents or make effective patent protection in India was very difficult at a point of time. These are all areas of concerns which have now been rightfully addressed by the government of India. In terms of the China jurisdiction, there was a report by the European Commission which said that forcing foreign businesses to share their technology in exchange for market access is a systemic problem in India, in China, because that was a compulsion which was made in China. Despite visible progress and attempts to reform China, China's low level of protection for trade secret and IP theft is still causing irreparable harms to European business. China also forces foreign companies to license technology below market rates as a precondition to access and operate in certain markets. This practice, of course, will discourage investment and put foreign operators, particularly in high-tech sectors, at risk of losing their competitive edge or advantage. The report also highlights how poor protection of intellectual property results in EU's importing vast quantities of counterfeit goods. Now, below, if you see the 2 points, China is at the origin of a dominant share of counterfeit and pirate goods arriving in EU in terms of value and volume. More than 80% of the seizures of counterfeit and pirated goods in European Union customs authority of European Union originate from China and Hong Kong, according to the European Commission report. Now, identifying the international opportunities. Now, when you talk about promoting IP as a jurisdiction, when you talk about IP jurisdiction and IP friendly jurisdiction, what are the key strengths these jurisdictions have got, which should be imbibed by the countries so that they are looked upon as a very IP friendly and IP governance regime? The world's leading innovation countries need a targeted, coordinated approach to support a broad goal of encouraging more countries to adopt policies that promote global innovation. US Chamber of Commerce, in its International Intellectual Property Index IIP 2019 report, has ranked the following countries in the top 5 based on their framework of intellectual property protections, which is US, UK, France, Germany, and Sweden. India has now gone up. It was not in the position which was expected, but it has now gone 8 steps up, and in 2019, it is now at 36th position, which is a great improvement, because going 8 spot ups means that the world is now looking to you, that you have done great development on the IP jurisdiction side, where your laws, your policies, your governance, your processes, and the courts have really contributed to creating India as a favorable IP jurisdiction. What are the key strength areas which are highlighted by this index report, so that when these countries are recorded as top countries, what is that greatness which is shown in that, including that for India? For United States, the new USPTO guidance covering Section 101 patentability, Section 112 claiming rights to computer inventions. It was global leader and standard setter for the protection and enforcement of IP rights. Sector-specific rights and protection in place across all categories of the index. Reform efforts to patent opposition proceedings by USPTO in 2018 and 19 should provide a greater balance and address concerns over unpredictability and uncertainty. So these are the strength areas which have been highlighted. What was the key areas of strength which was highlighted for United Kingdom? A strong and sophisticated national IP environment, a model for injunctive relief for right holders while battling online infringement, overall strong cross-sectoral enforcement environment highlighted by the work of a specialist crime unit and cross-industry and government cooperation. However, there was one point which was highlighted in this report, is that there is uncertainty over Brexit and impact on UK's national IP environment and existing EU laws and standards. So Brexit earlier was an issue, decision has been taken, but that uncertainty in the environment still remains, which will have an impact on the UK's national intellectual property environment. In terms of France, the key areas of strength highlighted was there is a generous R&D and IP specific tax incentives in place through an R&D tax credit and special patent box tax rate on income derived from qualifying licensing income and or sale of the patent or patentable technology. Number two, injunctive reliefs available and in use through court orders for disabling infringing content online. Strong and sophisticated national intellectual property environment, which is now also one of the great features of India jurisdiction. In terms of India, the key areas of strength which was highlighted in the International Intellectual Property Index report. 2019 precedent-setting case law on online trademark infringement and damages. We also saw dynamic injunction which was granted, which is one of the landmark judgments which have happened. The new pilot PPH program between the Government of India and Government of Japan for work sharing and therefore increase in efficiency and faster processing of the patent application is a positive step. Generous R&D and IP-based incentives, global leader on targeted administrative incentives for the creation and use of IP assets for small and medium-sized enterprises, strong awareness raising efforts on negative impact of piracy and counterfeiting. These are the key areas of strength which have been also highlighted for the India jurisdiction. This is my presentation. This is my bio. This is my presentation on enforcing IPR beyond the boundaries. I thank all the audience and the organizer. Any questions, I can take it up later on. Thank you very much once again. Thank you.